Hello. Declaring somebody inapt goes, at least on its face, against that person's rights, human rights, civil rights. Therefore, it's not that easy to declare somebody inapt. In the situation when such a person was foreseen, or at least thinking that it's conceivable that one day he or she might become mentally, legally incapable, that person might have prepared a protection mandate, basically appointing in advance a person that would be taking care of him, her, and her property in case of incapacity. But again, even having such a mandate is not enough for that person to suddenly become their caretaker and legal tutor, legal curator, mandatory administrator of property of that person without a court decision. And such a court decision is called, at least in Quebec, homologation of a protection mandate. In a way, it's similar to probation of a will. So once somebody have started to become legally incapable, already there more or less, for the person designated in the protection mandate to get all that power, there should be a court judgment homologating this protection mandate. So what should have been done to make it valid? Sometimes psychosocial evaluation is done first, sometimes medical evaluation is done first. That depends on where and how the person, somebody notes, like recognizes that the person is not totally there anymore. It might be when somebody is hospitalized for some different reason. It might be because of some neighbor reported that. It might be because of some friend or family member noted that. But very often it happens before the concerned person is getting totally incapable. So there is always a point where people around might think that the person is no longer capable of taking care of himself and his or her property. But that person, and unfortunately that is one of the indications of dementia sometimes, that person sees no reason to consider him or herself with diminished mental capacity. So whoever is bringing that up might face significant hostility on the part of that getting to incapability person. And therefore, family members, friends, especially thinking of what is there in the will or what might become there in the will, they might delay this moment to declare somebody incapable. So it's, again, not unusual when the first who notices that would be some nurse or some medical specialist or just some stranger or even a busybody. So somebody who is not necessarily close to that concerned person. But anyways, when there is a signal like that, when maybe somebody called the office of the public curator, either specifically hired, maybe by the mandatory him or herself, or just imposed, the social worker and medical specialist prepare their evaluation reports. There are prescribed forms for that. You can download them if it's needed. Usually a social worker knows how to prepare a psychosocial report, and a medical specialist, psychiatrist, gerontologist, they know how to prepare medical evaluation. If, based on the observations of those professionals, it seems that the person is really losing his or her mental capacity, then whoever was involved initially should inform or other concerned people like family members, friends, neighbors, whoever is interested, caring about that concerned person. Depending on, again, the situation, relationship, there might be even an interview, a conversation with the concerned person, him or herself. Sometimes not at this point. But anyways, it should not be done in secrecy. So people around, those people who are normally present in the life of that person, should be informed. Then, based on the documents and the discussions, the court application is prepared for homologation with all the evidence and sometimes witnesses, but necessarily the psychosocial and medical evaluation. In those evaluations, sometimes there is a specific recommendation to declare the person inaptent, sometimes to proceed with homologation, sometimes not to proceed with homologation, but to establish instead a protection regime, a tutorship, where the public curator is usually involved. That happens if during the evaluation, the social worker, particularly a social worker, or it's rarely the medical um, specialist, but usually a social worker, who might think that the designated mandatory would not be the best choice in the circumstances for the concerned person, or maybe the incapacity is only partial, but slight, so the full power under the protection mandate is not recommended. Anyways, so whatever is there should be a court application. And as usually the judgment is not coming fast, at the same time, there should be an application for provisional measures, meaning that the judge should appoint somebody in the meantime, at least to administer some property and to take care of some things, particularly like medical care, for example, depending on the situation, the condition of the person. Usually it's granted for half a year. Sometimes it's extended, but eventually there is a judgment. There is a judgment if everything goes by the recommendations, if there is no contestation on behalf of the successful contestation on behalf of the concerned person, him or herself, on behalf of the public curator or somebody else. Well, eventually there is a judgment of homologation, and then the mandatory is now like legally able to exercise the powers to basically make decisions for the concerned person instead of the concerned person. This is the difference from the power attorney. The mandatory under the power attorney makes decisions together in parallel with the mandatory, the person who granted the power attorney. But in case of the protection mandate in case of incapacity, once homologated, the concerned person has no longer rights, like power to make his or her own decision, at least to the extent prescribed by the court. And instead of that person, the mandatory or mandatories make those decisions. Again, to avoid as possible abuse, usually the reevaluation periods are established, or at least, if not, if something is changed, either somebody noted that the mandatory is not taking good care of the concerned person, or the medical condition, the mental condition of the concerned person becomes better. For example, some new treatment appears, or some scientific achievement allows to, or just the person's own health. For example, it was not because of an old age, but because of some accident, for example, or some trauma, or some aftermath of some illness. So the person is getting better. And even if there is no prescribed period of reevaluation in the judgment, that person could hire a lawyer, or somebody else who is interested could hire a lawyer, or even without a lawyer, go to court and ask to reevaluate and, if necessary, change the judgment. So the judgment of homologation of protection mandate is not irreversible, is not like final. There is always a way to redo if necessary. So this is it. Thank you, and have a nice day.